part 2 of the findings of the Director of Corruption Prosecution, Keisha Prince Kameka, reviewing the referral of Andrew Holness's statutory declarations by the Commission for the years 2019 to 2022 into allegations that the Prime Minister made false statements on his statutory declarations against the law. In part 2, we are going to continue the reading of the findings and look at the remaining 2 accounts as well as the corruption prosecutor's rulings. So sit back and hold tight. But before we continue our readings of the prosecutor's report, let me welcome each and every one to Jamaica 411. It's always a pleasure having you by, keeping me company as usual. If you're joining me for the very first time, welcome, welcome. Please give the video a thumbs up. Also, subscribe, share, and feel free to leave your comments in the comments section. We're very welcoming there. Thank you. And to my subscribers and regular viewers, welcome back. Always nice to have you and to read your comments. I'm sorry in the last video I wasn't able to respond to many, but I will try my best. But you know the ropes. You're going to go ahead and give the video a thumbs up from now on and share. Then you rejoin me. And of course, I thank you in advance. Okay, now time for business. So to begin where we left off in the other video, it states here, Bank of Nova Scotia account number 42. That's where we left off, right? Now at 15, paragraph 15, the prosecutor, Keisha Prince Kameka, said, this account was opened on July 28, 2005, as stated in the exhibit, and is jointly owned by the Honorable Prime Minister and another. The authorized officer in a statement exhibited a transaction history for the period October 31, 2017 to October 31, 2019, and period October 31, 2019 to April 5, 2023, for account number 42. The Honorable Prime Minister is properly identified as one of the account holders by this record. In other words, there's no doubt about this one now. He is definitely a joint holder of this account, and this one was left out of his statutory declaration. Right? Great. So we established that. Of note, no transaction was observed between this account and any other account associated with the Honorable Prime Minister. Now, in her findings, she said, each month during the period, the account was noted to be credited electronically with transactions detailed as Electoral Office Admin, among others, none of which are, however, connected to any other accounts held by the Honorable Prime Minister, whether solely or jointly. So it appears as though this office worker, she was working with the Electoral Office of Jamaica. Is that what this means? Electoral Office Admin? Anyway, she went on to say it can be concluded with regard to this account that the Honorable Prime Minister had an obligation during the relevant period to declare same in his statutory declaration. Yes, because he is a joint holder. He did not declare it, she said, and he should have. So when it came to account number 42, we can agree that things looked a little dicey for Andrew Holness. But let us continue to the BNS account number 21 at paragraph 16. The prosecutor stated in her report, this account was noted to be held jointly by the Honorable Prime Minister and his father. The authorized officer from the Bank of Nova Scotia noted that Mr. Holness was added, this is in quote, as a joint account holder on January 27, 1989, when the account was first opened. At that time, the Honorable Prime Minister was a minor. The reference to Mr. Holness, in quote, in the statement is unclear as to whether it is the Honorable Prime Minister or his father that is being identified. You know, when you go to court with matters, you have to be very precise with your language, otherwise them defense attorneys there, or the opponent's attorney will tear you to pieces. Anyway, let me continue. It is nevertheless important to note that the Honorable Prime Minister's signature was recorded on July 29, 2005, as having been added to the account, and the Honorable Prime Minister's name was not removed from the account until September 2023, following his written instructions to the Bank of Nova Scotia. Additionally, the transaction history produced by Bank of Nova Scotia for the period October 31, 2017 to February 5, 2023 identifies both persons as account holders, with his father appearing to be the primary account holder. Consequently, the Honorable Prime Minister had a duty to declare Bank of Nova Scotia Savings Account number 21 in his 2021 statutory declaration. Remember, it is a 2021 statutory declaration that was referred. So even though they are going all the way back, the investigator looking all the way back to 2017, what was referred to her was the 2021 declaration. So she had to stick to that, because if you go to court with anything else, them attorneys on the opposite side, Holness's attorney, would tear it to pieces. And so would the judge. Great, so let us continue. So we can safely conclude that for these two accounts, account number 42 held with the office worker and the account held with his father, account number 21, Andrew is definitely into some kind of trouble, right? He's definitely an account holder. He was supposed to have declared it in his declarations. He gave some reasons why he didn't do so. He said that these are not his accounts. He's not certain or recall how his name was added to the office worker's account, but for his father, it was a survivorship. And he also said it was for emergency reasons why his name would have been added to his father's account. He said these accounts and the monies in it, which was small, did not form part of his assets enough for him money, and he's not the primary holder. All right, so let's continue to where it says now, is there prima facie evidence of making a false statement by omission for Bank of Nova Scotia savings accounts numbers 21 and 42? And remember, that term prima facie means that on the face of it, accepting the evidence as is until proven otherwise. Right. So at 17, it says, to determine if the omissions amount to an offense under the noted provisions, two main legal issues require ventilation. Two things she has to prove. Can non-disclosures or omissions be regarded as false statements for the purposes of the offense, particularly when statements are generally regarded as being expressed, that is, averments of fact? And two, whether or not there is sufficient evidence to establish that the declarant knowingly omitted the asset from the relevant statutory declarations, or in the circumstances of the present case, Holness's case, it is to be deemed in the absence of the necessary intent, as has been suggested by his responses. What does she mean by the first one, though? Can non-disclosures or omissions be regarded as false statements for the purposes of the offense, particularly when statements are generally regarded as being expressed? Meaning that for me to say something or be regarded as saying something that is false, it's usually something that I either say or wrote. So it's either written or oral. And then you say, oh, but that statement is false. But in this case, it was an omission, meaning that nothing was either said or written. It was just left out. So she's now going to argue whether or not an omission can be regarded as a false statement. So let us continue to read and hear what she had to say about that. The mischief the law is seeking to address by mandating the submission of statutory declarations would be unrealized if intentional non-disclosures were not treated as false statements. So what she's saying is, if you don't treat non-disclosure as false statements in the declarations, then the whole purpose of the law will be defeated. And she goes on to explain, the highest level of probity is necessary for public officials in the conduct of their functions, and this is what the law seeks to ensure in requiring that accurate and complete statutory declarations be made. In other words, how are we going to be able to judge whether corruption is involved if the person is allowed not to submit declarations that are complete and accurate? You see what she's saying? Yes, that's the point she's making, I think. It follows then that the law would be rendered an absurdity if the offense of making a false statement in a statutory declaration was interpreted in a manner that excluded intentional non-disclosure. I think I can agree with that. Do you agree? You can leave your comments in the comment section. Thank you. Additionally, the statutory declaration requires execution in the presence of a justice of the peace to whom the declarant solemnly and sincerely declares that the particulars given therein are, to the best of his or her knowledge, true, accurate, and complete. And there is the rub. Once you met that declaration and they found out that it is not, as you say it is, true, accurate, and complete, they have to investigate to find out why or whether this was an accident or deliberately done. And then that might lead now to other things. So in order to determine what is what in this case, she has resorted to, as all lawyers do, to look at case file. It is called the Regina versus Fiona Jones and Desmond Witcher, an English case with similar circumstances to the one that she's looking at in terms of false statements. And she would like to know what were the findings of the court in that matter. And this is what is going to guide her action, because if this matter goes before court, chances are Holness's attorney will be hauling up this matter, and very possibly the judge as well, to argue their case and the judge to make his or her judgment. Get that? Wonderful. So at 19 it says, the case of Regina versus Fiona Jones and Desmond Witcher is instructive, you see, and is outlined as follows. So she is now given the background to that case. A general election was held and Jones was elected as a member of parliament for the Newark constituency. Mr. Desmond Witcher served as Jones's election agent. Following the election, Mr. Witcher made a return of the election expenses incurred by Jones at this election, and both he and Jones declared that to the best of their knowledge and belief, the return was complete and correct. The declaration was made pursuant to Section 81(1) of the Representation of People Act 1983 UK that mandates both the election agent and the candidate to deliver to the appropriate officer a declaration in the form specified in Schedule 3 to the Act, which provides for a declaration that the return is to the best of the candidate's and the agent's knowledge and belief, a complete and correct return as required by law. Both he and Jones made the required declaration as to the completeness and correctness of that return. Section 82(6) of the Act, under which the appellants were prosecuted, provides if a candidate or election agent knowingly makes the declaration required by this section falsely, he shall be guilty of a corrupt practice. One of the two major charges made by the prosecution was that in the return made under Section 81, verified by both appellants under Section 82, there was an exclusion or non-disclosure of an office rental expense incurred during the campaign. Held, which means this was a ruling of the court. Before any defendant may be convicted of an offense under Section 82(6) of the Act, the tribunal of fact, in this case a court, must be satisfied: 1, that the defendant made a declaration as to election expenses as required by the section; 2, that such declaration was false in that expenses which should have been included were omitted, or expenses which were included were understated, or both; 3, that the defendant knew such declaration to be false, either because the defendant knew that expenses which should have been included were omitted, or because the defendant knew that expenses which were included were understated, or both. So these are the three things that must be proved before a person can be convicted of having made a false statement under the Act. That's basically what the judge was saying. She went on to say the third requirement is crucial for present purposes, meaning in this case, as it defines the dishonest knowledge which constitutes a mens rea of the statutory crime and which must be established before a defendant is convicted. Can't lock them up until you prove that they had knowledge. Them know what they were doing. That's what mens rea mean, that they knew that what they were doing was wrong. Right? Great. At 20, she said, the issues in the matter under consideration are analogous to those noted in the preceding authority and touch and concern non-disclosures in a statutory declaration, and whether or not this amounts to making a false statement. What does that mean? Analogous means that it's a similar case. Holness's case is similar to the one that she described. And she's comparing that case and the outcome in the courts to bring some clarity to what it is that is likely to happen if she was to bring Holness's case to court. You following? Great. And when she said noted in the preceding authority, that authority is a case file. It's either referred to as a case file, citation, or authority by the attorneys and the court alike, because it's these authorities and the findings of those judges that is used to determine or influence the determination of the judge in a case before them if that case is similar to the one that they are looking at. Follow? Great. So let me continue. The three elements outlined by the court in that case that the prosecution must establish are noted, and that test will be applied to the circumstances of the current case, which is the Holness case, in examining the evidence and whether it properly gives rise to a resultant prosecution. Meaning that, okay, she's going to use the three elements that the court is saying. You need to make sure so you have them three elements in your case before you bring them before me, All right, otherwise you're not going to get a conviction. That's basically what that is saying in layperson term. Great, let me continue. So here now she's taking those three elements needed to secure a conviction one by one and applying it to Holness's case to see whether or not the evidence before her is sufficient for her to mount a viable prosecution. So let's look at it too with her. At number 1, it says, the defendant made a declaration as required by law. As detailed above, This element has been satisfied as the Honorable Prime Minister was required to submit the statutory declaration which he confirmed was in fact made by him. Of critical importance is the previously referenced certification signed at the end of the statutory declaration form submitted by the declarant, in which he solemnly and sincerely declared that the particulars given therein are, to the best of his knowledge, true, accurate, and complete. So he took that declaration, he signed the declaration before a justice of the peace. That is what that is saying. So that first element is satisfied. So she good to go right there. Second one now. The declaration was false in that assets which should have been included were omitted. Then she goes on to say, the review conducted of the statutory declarations submitted by the Honorable Prime Minister for the period 2021 determined that the said statutory declaration did not include the questioned Bank of Nova Scotia accounts number 21 and 42, jointly held by the Honorable Prime Minister and others during the relevant period. As previously established, this was an asset that ought to have been disclosed. Having omitted an asset that should have been included, the second element in Regina versus Jones and Witcher is also satisfied. So 2 out of 3 so far. That's 2 out of 3. And at this point, things not looking very hot for Andrew Holness at all. Not at all. But the last one now is the third element. And it is a crucial element if she is to mount a successful prosecution. So let's look at that third element and what her findings were. So for the third element, she stated the defendant knew such declaration to be false. Now she needs to determine that. In accordance with the legal requirements regarding intent, where establishing knowledge by the accused is a necessary component of proving the offense, it is essential to assess the supporting circumstances and the conduct of the declarant to determine whether he can be deemed to have known that the submitted declarations were false. She goes on to say, the interactions documented through transactions related to the accounts prior to the completion and submission of the statutory declaration, as well as the responses provided by the Honorable Prime Minister, will be examined in turn to ascertain the Honorable Prime Minister's intention at the time the alleged false statement was determined to have been made, which of course is in the 2021 declaration, right? So she is now examining the evidence pertaining to the 2 accounts, number 21 and 42, to see if she can find evidence that would betray that Holness had knowledge and intent to leave these accounts off the statutory declaration. That's what she's looking for. So at 21, she said, the Honorable Prime Minister, when invited by the Commission to provide an explanation for the omission of Bank of Nova Scotia account number 21, maintained that, and they're quoting what he said, this account belongs to my father, Morris Holness. Other than my name being added to the account many years ago as a precaution in the event of an emergency, I claim no interest in the account and it is not part of my assets. And BNS account 21 is primarily held by my father, Morris Holness. My name was added to this account for survivorship reasons. So he gave 2 reasons. One, that it was for emergency, why his name was added, and the other, that it was for survivorship reasons. In case father died, he would, of course, the account would transfer automatically to him. When asked specifically about the source of funds for this account, the Honorable Prime Minister responded, and they're quoting him again, I am not able to say with certainty and completeness regarding the source of funds for all the deposits to this account. Mr. Holness operates a farm selling livestock and produce. From the statements provided at Appendix 10, some deposits appear to be proceeds from his farm. There were also transfers from my personal accounts to BNS number 21. So he was giving daddy some money to as well as mommy. Good son, good son. As previously indicated, a key factor in determining liability for making a false statement in a statutory declaration is whether the party had actual knowledge or a reasonable belief that the declaration was false, which in the present case occurs by virtue of the omission identified. At paragraph 22, she said, the transaction history provided for BNS account number 21 offers support to the explanation provided by the Honorable Prime Minister and details approximately 10 transactions between the Honorable Prime Minister's personal account held solely by him and the referenced joint account, which is 21, for the period 2017 to 2023. So what it's saying, she found at least 10 transactions where indeed the Prime Minister did transfer some money to his father's account. That's what she's saying. So she proved that what he was saying was true. No additional material has been provided on file to contradict this explanation. What does she mean by that? The investigator has not provided her with anything or any reason to believe or any evidence to prove that what the Prime Minister was saying was not so. She would have needed such an evidence or evidences to be able to mount a successful prosecution in the court. You're following that, right? Great. Having requested the Honorable Prime Minister and been provided with his account, which goes directly to the issue of intent as an element of the offense, the onus falls on the prosecution to provide cogent, admissible evidence to satisfy the court that the required mental element has otherwise been proven. Additionally, there was nothing on file to suggest impropriety with regard to the source of funds or that the amounts themselves required additional scrutiny during the course of the investigation, which would provide support inferentially to establishing that the omission was intentional. Given the evidence that has been made available, the prosecution would be challenged in establishing to the requisite standard this critical element of the offense. What is she saying? She's saying, taking the evidence and the fact that Holness provided an explanation, the onus to prove intent has now shifted from Holness to the prosecutor, as she now going to have to show evidence to support her argument that he had intentionally left it off. When she look at what she has before her, she look at the source of funding. An explanation was given that it was the father's account where he put his earnings from farming, right? And some of the money came from daddy as well. The amounts that are in the accounts, she's saying, was not of a large proportion that should have invited scrutiny of the account, right? So it's a small amount of money we're talking about. The source of funding was more or less proved. The Prime Minister's explanation was sufficient, and therefore she's saying she can prove that he intentionally left it off because the evidence that is before her is not enough to even infer that he left it off intentionally. And that's the point that she's making. So if she was one of those type of, prosecutors who are, I don't know, overzealous, and she decided to take this matter to court, she seems to be saying, right? She would be challenged to establish that he had intent, and therefore what she would have been doing is wasting the court's time, her time, his time, and she would end up losing the case because the critical element of intent on his part is missing from the evidence that is before her. Now, that is a situation with his father's account, number 21. What about the other account, number 42? Let us read and see what she says here. At paragraph 23, when invited by the Commission to offer an explanation with regard to his association with BNS account number 42, the Honorable Prime Minister referred to an appended document with details about the account. He stated, BNS account number 42 is primarily held by Elizabeth Reed, who worked in my constituency office more than 20 years ago. I recall encouraging her to open a bank account for her wages to be paid online. I do not recall the circumstances under which my name was added to her account, and I have written to the bank to have my name removed from the account. The Honorable Prime Minister also mentioned that he was unable to comment on the source of funds used to maintain BNS account number 42. At 24, she said, it is important to note that while the referenced appended document included statements detailing transactions relevant to this account, no transactions were observed between the account being considered and the accounts attributed to Holness, whether solely or jointly, during the period 2017 to 2023. She goes on to say, there was observed, however, for this account, monthly payments from the Electoral Office. Yes, I was right. In keeping with the purpose as asserted by the Honorable Prime Minister in his response. Additionally, no other evidence has been provided to contradict this account or suggest use of this account beyond the purpose as has been indicated. The money that was being deposited was coming from the Electoral Office. That's what she's saying, and no interaction at all between Holness and this account. Right? So there's no evidence that she could take to court to show that he deliberately left this off his statutory declaration, which of course is an offense. At 25, she says, in accordance with the principles outlined in Regina versus Jones and Witcher, therefore, the prosecution would again be challenged to establish that the omission was intentional as required for the knowingly element of this offense, in the face of even greater support for the explanation that has been provided. So, again, she's saying, Holness was asked some questions and he provided answers to them, and there is no evidence contradicting what he said. Indeed, as a matter of fact, what she's saying is that the evidence in fact supports and proves the truth of what he had said in his responses to the questions asked in the interview. So the three elements having been thoroughly examined by the prosecutor, she now comes to her ruling in the matter. And here she says, in light of the foregoing, there is insufficient evidence on file to establish that the Honorable Prime Minister, by way of omission, made a false statement in his statutory declaration for the period ending December 31, 2021, as it relates to BNS savings accounts number 60, 42, 21, and 64. Accordingly, no charges are to be laid. So she's saying that the evidence before her, the first two, of course, you know that Andrew Holness's name is not even on his mother's account. That's the first two. The other two now, she established that she could not prove that Andrew Holness deliberately left these two accounts off his statutory declaration. She could find no reason why he would have done so. The amount of monies are small. The explanation as to the source of income was established. In the case of his father, he was giving his father money. Plus, his father was a farmer. No money apparently coming from his father's account to him. And in the case of the constituent, she was being paid by the electoral office, not him. And there was no transaction between his account and hers. And therefore, the explanation that he gave was not contradicted by any evidence before her. And so her conclusion is that he did not make a false statement on his statutory declaration, because for her to make that declaration, she would have had to prove that he intended to lead these accounts off, and that she could not prove with the evidence before her. That is what this means. Are you following me? Great. So the Prime Minister cannot be said by anybody that he made false statements on his declaration. It can only be said that he was investigated for having done so, but then he was exonerated by the evidence and the conclusions of the Director of Corruption Prosecution, whose name is Keisha Prince Kameka. I like that name. It's a pretty name. Anyway, that's what I have for you today. Thank you so much for joining me, being so patient as usual. Please remember to share the video and leave your comments in the comments section. Until next time, take good care of yourselves and walk good.